Now, the fact that we found almost 10% of judges being corrupt, usually they say that if you find one person being corrupt, the likelihood is that you probably have a few more. Does this suggest there's a much bigger problem than 10%?
It must be. If you look at the methodology these Tiger Eye used, they went and listened around. Who are the judges with a reputation for corruption? So this is a very rough sample. They just asked, who are the judges and the reputation for corruption? And they tried to get some in every capital. Try to make it as national as possible. And if you look at the figures, the closer you are to Accra, the more they demand. The further they are away from Accra, the less they demand. Some took yams, some took goats, some took a sheep, some took 600 cedis. Right.
I found that surprising, actually.
Well, don't. Think of it. Assume that judge makes 600 cedis extra every day, 20 working days in a month. That's 12,000 extra income. So this was just the one that has been caught. Am I shocked? Yes and no. No, because this happens. As a young practitioner, I came close to a couple of them. If it had been today, I'd have written petitions. But as a young practitioner, I came close. I didn't see money changing hands, but you could smell it. The problem has always been evidence, because in criminal trials and in all of this, a man must be proven guilty beyond reasonable doubt. And he is presumed innocent until found guilty. So that even if you have him on camera receiving the money, there's still the presumption of innocence. That evidence has to survive the test of a judicial process and be admitted in evidence and be relied upon by the judge or judicial or quasi-judicial body. And so these are early days yet. The real things are yet to come in. And I must say quickly that I really do appreciate the speed with which the government system and the authorities have acted. I have a fair idea when they received the petitions and the speed with which they've acted. One of the first things they did was to issue an immunity and indemnity letter to Tiger Eye and Nanas to say that under the Whistleblowers Act, he's absolutely protected so that he is not liable to criminal prosecution for paying the bribes, and he's not liable to civil action as long as what he has put out is true.
But could somebody have initiated an action like that?
But for the Whistleblowers Act, some action could have been initiated because he bribed somebody. I mean, you can't deny the fact that he took part in the offense, but it was for the public good. And so this was important that that act was passed, and the government system has assured him that we are with you. And so I am very grateful for that as a Ghanaian. The Judicial Council has acted with such speed. It's amazing. After 2 days of meetings and after meeting announced, people have been suspended. Hearings start tomorrow. My confidence in the system has been boosted. I hope that we see it to the end. Those who are innocent ought to be left alone. Those who are not ought to be dealt with. Let the chips fall where they may.
Are you surprised at some of the names that have come up?
Yes. Yes.
Which one surprises you most?
I can't repeat names. For now, we all presume not to know the names. But some of these are my friends. Some of these are classmates. Some of these are schoolmates. These are people I know very well. I can't be a very happy person right now. And some of these have appeared before. There are some I have cases pending before. And so hearing this and knowing what is probably coming out, it's a blow to my solar plexus, big blow. But it's a human institution. We all have our failures and failings. So maybe this is it might even have been a one-off, but it's on camera.
I've heard some lawyers say that the lawyers who were excited about this expose. Are you one of those?
No, I'm not. I'm more philosophical about it. You see, it's somebody's life. I mean, if one person is found guilty of this, he or she is finished in the legal profession. The reputation of that person is gone forever, even before his or her children, and the children who are going to go to school, and their mates would have watched this. So there's nothing to be excited about here. This is a very serious incident.
Even in instances where some of the judges who have been named are people who may have adjudicated cases which you thought you should have won, but you lost.
Yes, but I have to deal with evidence as I have it. Sometimes you come out of a case and it strikes you that something odd is going on, but you can't put your finger on it. I can't now jump in and say, oh, okay, that case went this way because the judge was probably influenced. There are other instances that I'm bound by the ethics of the profession not to disclose it. But there are the other instances, at least one instance where my client has said, but I paid the judge.
Okay.
And then I'm bound by my ethics to keep quiet because I can't disclose it. And so this is deeper than we think. And it affects each and every one of us. And we lost the case. And he said to me angrily, but I paid the judge. But you find out that he paid somebody who was going to pay the judge. So you can never prove that money reached the judge. And he won't disclose names. And even if he discloses names to me, I can't. Ethics of the profession, I'm bound to keep quiet. And so I don't think there's any lawyer who can say that you haven't come close to it, either it being used against you or your client benefiting from it. As a much junior lawyer, a clerk of a court came to the firm saying the judge just said he should come to talk to the partners about a case we're doing. They drove him away. And so this has always sort of been there. And it is interesting to see it play out in this way. When Ghanaians get to watch this, I mean, there are going to be a lot of drooping jaws. I mean, wow. It took place in homes, chambers, on the side of the streets, parking lots, everywhere. Goats were delivered to homes, bleating. Yams were delivered as bribes.
Now, we've talked about those who delivered the bribes. There's some who probably took the monies and never sent it to the judges. But there's also talk about the fact that we can't leave out the lawyers because they would have been involved in this.
I'm not sure Anas found lawyers. I think we need to look at the story very critically. He went out to look. And so he literally looked, okay, Judge A, I hear she's corrupt. So he goes to look at the course list, the list of cases the judge is looking at, and picks one. And then goes to the judge to say, my brother is the second accused. Please acquit him, but put the others in jail. He's never met the so-called brother. That person is walking the streets of Accra not knowing that it is this sting operation that let him off.
Okay.
And he hands the money over, and the judge acquits and discharges the second accused. In some instances, he doesn't know what happened because once he paid the money, they abandoned the chase. So in some of the instances, he doesn't know whether the judge performed or not. But hey, the money's changed hands, and once it's caught on evidence, once it's caught on TV and there's evidence, what can one say? So this is a deeper research than we think, and he has hundreds of hours of recording that he's given to the judicial system. That gentleman has done a good job for this country, whether it checks out or not.
Welcome back. This is Newsfile, your most authoritative news analysis show. Here on Newsfile, we put Ghana first. We'll be speaking to Professor H. Kwesi Prempeh, who is Professor of Law at Seton Hall University School of Law, Newark, New Jersey. He has been saying that the process that is being conducted presently in camera ought not be the case. Let the public have access to what is going on as far as the inquiry at the level of the judiciary is concerned. We'll be speaking to Justice Augustine Obor. Augustine Obor, he is a private legal practitioner. He's been a teaching assistant at the Ghana School of Law. He's a former state attorney doing about a decade of criminal prosecutions. He says Anas lured the judges and judicial staff. I ask him, so what? We'll be speaking to Justice Sram Sai. He is a private legal practitioner teaching law at GIMPA, and he also works with that program that provides special legal training for everyone. They call the program Law for Everyone by LADA. And if you know LADA, that's the Law Development Associates. Like me, Justice Sai writes writes quite regularly in the Daily Graphic and other online publications. He writes articles on pertinent legal issues that come up in the nation. The latest being about the debate on the need to expand access to the Ghana Law School. He is against those advocating for an expansion. I'm one of those who are the proponents. Now, was also here in the studio, Clara Berry Kasati. She is a managing partner at Kasati and Associates, teaches law at the University of Professional Studies, graduated from the Ghana Law School as the overall best student in 2009. I said we will get a lot of scholarship as well. Nana Atu Dazi is a private legal practitioner, former chief of staff under President Rawlings. He will take a few questions from me, including what he makes of President Rawlings' urging of caution on all of us and the manner in which we deal with these judges. How about the respected Sam Okudjeto's prescription that the video should not be shown? What does he think about those matters? Justice Francis Emil Short is a former judge and former commissioner of the Commission on Human Rights and Administrative Justice, whose boss is currently also going through the Article 146 process, seeking to remove her from office for alleged misconducts, and I'm leading that charge. How coincidental to host the show today. John Indebugri, he is lead counsel for 14 of the lower court judges suing the Judicial Council, and he is a private legal practitioner, of course, and he's a former MP for Zebila. Also, one lawyer who is with a team of lawyers that in the coming days, on Monday we will hear a lot about them, will join us. They are for the High Court judges who also, among others, are heading to the court to seek to injunct the showing or broadcast of the video. And they have solid legal grounds to make those arguments. We'll share some of them with you on the show. Thank you very much once again. And I want to say welcome to my guests in the studio, and they include Abdul Malik Kweku Bako. He is my finest street pocket lawyer in town. Good morning, gentlemen and lady.
Good morning.
Right. So Kweku Bako to my extreme right, and Clara is here, Nana Todazi is here, and also John Indebugri to my extreme left. Now, the Office of the Chief Justice issued a statement yesterday, and I'll start by reading that statement. Well, I don't forget to tell you that the first interview, recorded interview that you heard was Ace Kojo Anan Ankoma, who was speaking to Israel Lai. And I read this statement. It says, the Honorable Lady Chief Justice is awaiting the response of the 12 High Court judges, and this was issued yesterday. It's awaiting the response of the 12 High Court judges involved in the, quote, bribery scandal, unquote. They are, now listen up, His Lordship Justice Frank Opoku, Justice Charles Quist, Justice Kofi Isel Mensah, Justice Mustafa Logo, Justice Uther P. Derry, Justice John Ajet Nassam, Justice Kwame Ohene Isel, Justice Ernest Obimpe, Justice Ivy Hayward Mills, and Justice Gilbert Eyisi Ado. And that's 10. They are supposed to be 12. The statement continues. The remaining 2 are retired justices, namely His Lordship Justice Alhaji Muhammad Ahmed Mustafa retired. He retired on the 1st of May 2015. His Lordship Justice Yao Ansu Jiabo retired. He retired on the 6th of June 2015. The attention of His Excellency the President has been drawn to this fact. In view of their status as retired justices, the two are not subject to the impeachment proceedings provided under Article 146 of the 1992 Constitution. Meanwhile, the 10 serving justices have up to Monday, September 14, 2015, to respond to the petition, following which the Chief Justice, in accordance with Article 146(3), would determine whether there is a prima facie case against them. Also, among the 22 Circuit Court judges and magistrates who were referred to the Chief Justice to be dealt with in accordance with Article 151 of the 1992 Constitution, 2 have since April 1, 2015, been elevated to the High Court. As such, they cannot be brought under the provisions governing the lower court judges. The Chief Justice has therefore resubmitted the petition against the 2 justices to His Excellency the President for his directives. The 2 are His Lordship Justice Daniel Obeng and Justice Asma Akwesi Esiedu. The names of the remaining judges and magistrates are as follows: Her Honor Florence K. Otu, Alex Obeng Asante, Emmanuel K. Senu, Benjamin Y. Osei, Baptist Kojo Folson, Isaac Akwante, Albert Zoga, Courage Ofori Efreye, Sairam T.Y. Azuma. And then the magistrates are His Worship William Bafo, Michael Buama Jemfi, Paul K. Al-Hassan, Stephen Azuri, Asure, Stephen Asure, right, Stephen Asure, thank you very much, Senior. Kechiri Ata Owusu, Alfred K. A. Mensah, Frank Kingsley Opong, Samuel Ahiabo, Isaac K. Amwa, and Jacob Amponsa. So that is the entire list of the judges who have been implicated in the ANAS investigations. Well, as you know, there is a total of 180 persons being spoken about here. And out of that number, it is 34 that are judges. The rest are clerks and other staff of the judicial service. Now, let's get to business and deal with the matters as they have begun to unfold. The show is brought to you by the kind sponsorship of Bank of Africa, strong as a group and close as a partner. MTN, welcome to the new world. Sasso Spray, fresh and powerful. Star Assurance, creating smiles since 1985, celebrating 30 years of solid partnership. Lipton Tea, the #1 tea brand, and Yumvita, that is the delicious way to grow. Shortly, I'll be going on the phone lines to speak to Professor H. Kwesi Prempeh, and why he says the judiciary would do its the best service if the ongoing probe or disciplinary process is not done in camera. He will justify why he says so. Now, let me start with my guest in the studio. And I'd like to start with you, Clara. As a young practitioner, about how many, 6 years of practice or so, or more, how does this news come to you?
It's depressing. It's depressing, to say the least. I don't want to say it's shocking, because it is not like the suspicions were not there, or there was never any cause to suspect that some things were not right with certain people. But it's also encouraging in the sense that there is the hope that something would be fixed, because as a young practitioner, there were many who felt that industry wasn't worth it, that working hard, preparing your brief and putting everything into your brief wasn't worth it, and that you were better off probably looking for a grandfather or looking for networking where you could get certain people and have a shortcut. Now this video has come to encourage young professionals who want to work very hard, that at the end of the day, it is your industry that would make you stand out.
You are not saying that it doesn't pay to exhibit industry and scholarship in the court. We are talking about a total of over 150 judges across the country, 34 having been implicated in this, allegedly.
Yes, 34 have been implicated. We do not know the sample size. I don't know if you know the sample size. We don't know the sample size. 34 would suggest that it's about 10%. But even 10% is huge, assuming that the sample size was 100%. It is possible that the sample size was not 100%. But the perception has been there. The 34 judges have just come to give the proof, but the suspicions and the perceptions have been there.
Right. Nana, even the present Chief Justice, I've heard Chief Justice upon Chief Justice say there is perception of corruption within the judiciary. Some have actually said there is corruption within the judiciary. But what they have been doing is asking we, the citizens, on whose behalf justice emanates, from whom justice emanates, and on whose behalf the judges administer justice, to come forward with those, complaints so that they will deal with them. Here is the evidence. Isn't that what you have to say?
Oh, absolutely. Thanks very much for the opportunity. Speaking for myself, I think really this is 4 years late, you understand. This whole concept of produce evidence before action is taken, I think is unhelpful, particularly for an organization like the judiciary, because 4 years ago, I was counsel.
I'm waiting for your explanation, because I'm shocked to hear you say produce evidence before something is done is unhelpful. You're a lawyer.
Oh, absolutely. That's what I'm saying. I don't understand you must understand what I'm saying. That I'm saying that it is unhelpful. It doesn't mean that produce evidence. If I don't produce evidence, then you do nothing. That's the point I'm making. Once, as my lady said, the perception has been there all along. So the question is, what have we been doing so far? Suddenly we are dumped with 34 cases. That's a lot of cases, indeed. I can handle 1, 2, 3 or so. But all of a sudden we wake up and there are 34 cases, 34 cases. Questions will have to be asked and answers may have to pop up.
34 cases of
allegations
of luring, entrapment. We'll deal with all of those subsequently. Not 34 cases of judges who were taking bribes and were caught, but 34 cases of judges who were tempted to taste it and they tasted of it.
Well, no, I initially I was tempted to buy that. I'm not privy to the video. I don't know what it is. I haven't seen it except some transcripts that emerging in the on the what do you call machine.
Okay,
and they are disturbing.
Thank you. Now, just hold on briefly for me. Let's go straight to the United States of America and speak to Professor H. Kwesi Prempeh. Thank you very much, Prof, for joining us.
Good morning, and thank you, Samson, for having me.
We are very grateful that you are able to make time for us at this time of the period where you are. You say the judicial establishment doesn't get it. When the judicial system has been tarnished this badly and publicly by video-backed accusations of corruption, you do not do yourselves or the country any favor by conducting proceedings in camera. Why your preference for a process open to the public?
Okay, well, thank you very much. First, let me note that what we're talking about here are not the impeachment proceedings for high court and other superior court judges under Article 146, which the Constitution, of course, says must be done in camera.
Right.
The Judicial Council does not have control over that. What we are talking about here are those disciplinary and removal proceedings for inferior court judges, magistrates, and other judicial staff. Now, the removal of those is under the authority directly of the JC, or the Judicial Council. Now, that process is not regulated, therefore, by Article 146, so it need not be done in camera. My simple answer to the question, why open those proceedings up, is really why not. What is lost, in my view, what is lost by opening up the process? Conversely, what is gained by closing of the process? These are not ordinary times. These are exceptional times and exceptional circumstances. What has happened is an unprecedented public shaming of the judiciary, not just locally, but also internationally. The judiciary holds a very special place in our system of government. It is where we are supposed to go for a cure when we are aggrieved or victimized about an injustice, a wrong, even a crime. But when you have the cure itself now becoming the disease, or alleged to become the disease, then we know that it is time for some radical surgery. This is not the time for business as usual. I could take an analogy from normal litigation. Ordinarily, we don't open litigation we don't actually televise our litigation processes every day. Rarely when you have something like a first-time presidential petition, when the whole country is on edge, and the judiciary is on trial, essentially, I think that we did the right thing by actually televising it. It is that kind of exceptional circumstance that I see here. When we say that justice must not only be done but it must be done, we mean it not just in a figurative sense.
Okay.
We also sometimes mean it in the literal sense. Justice must not be done in the dark. It is why we keep our courts open. It is why we keep our judgments publicly available for general scrutiny. We must extend the same openness in a situation like this, in a very exceptional circumstance like this, where serious allegations of corruption have been made. Now, if I were one of the affected judges, the inferior court judges and the magistrates, and if I'm called to answer any of these charges, I would want an equally public opportunity to do so. After all, the allegations have been made very publicly, and they have been made in a mode and manner that is actually similarly public in a video.
Do I hear you suggest?
Yes.
Do I hear you suggest that for those in the superior courts, the high court justices, theirs also should be conducted in the public?
Well, I don't think that the JC has much choice over that. If I had my own way, which I don't, I would do that publicly as well. But now that is handled by the Constitution, I don't have much choice over that. But I'm saying that where the JC, I'm really talking here about the Judicial Council and the judicial leadership and what they can do.
That's so.
In my view, it saves the judiciary from any public doubt, suspicion or speculation as to what might transpire or be transpiring in these proceedings. Already, the Chief Justice has had to deny as untrue a news account of certain judges having reportedly been exonerated. Keeping these proceedings in camera will result in more and more of this speculation, guessing, gossip on the one hand, and then denial and refutation on the other hand. I think it should be avoided.
All right.
This episode is indeed a grave threat to the legitimacy of the judicial system, but I think it also offers, in a sense, a golden opportunity for the judicial leadership to do things differently and to carry the public along with them as they go ahead. And I see nothing to be gained at all, and a great deal to be lost in terms of public confidence if the Judicial Council were to proceed in these limited proceedings in secret.
Right. And you spoke about the reputational damage internationally as well. How do you estimate this scandal would impact investor confidence in Ghana, if any at all?
Well, I know we are. I'll get to that point. I know we are a bit upset as a country with the Ghana brand, so we are justifiably worried about what this might do to or signal about our suitability as an investment destination. We should be concerned, in my view, first and foremost, however, with the domestic impact. the impact on the Ghanaian public.
Right.
Because the first and most important clientele of the judicial service is the Ghanaian public. We are the main consumers of the service that our judiciary renders. If we do not trust in the quality of that service, if we do not believe that we will get fair and impartial and affordable and efficient justice from the judiciary when we need one, we will go elsewhere, locally, in search of justice. And in fact, most Ghanaians already do. Most Ghanaians seek justice predominantly from extrajudicial sources, from family, from chiefs and community elders, from the church and the mosque, even from juju and other fetish priests, right? And sometimes those who don't believe they can get justice in our cause take the law into their own hands. That is very important to note. They resort to self-help. This is what we have to worry about. So this is why I think that the judiciary must seize this opportunity to regain the confidence of the public, not just by undertaking a purge of these so-called few bad apples, but seizing this opportunity to do more substantial reform in the way the judiciary does business as a whole. Now, some of the things that fuel these kinds of problems with corruption are actually very mundane things that we take for granted. Habitual adjournments in our courts, delays, unpublished judgments, improper fraternization of lawyers and clients with judges, improper ex parte dealings. All of these create the environment that fuel corruption. Judicial appointment and promotion processes, I think we can make them more transparent and include a bit of public participation. I learned from the press release yesterday from the CJ's office that two of the judges alleged to be involved in this scandal were promoted to superior court status just this year.
That's so.
Perhaps if there was more openness and some opportunity for public input into the appointment or promotion process, we might have had an opportunity for persons with knowledge of this scandal at the time to have made some input into the promotion of these judges.
What sort of best practice are you using to make this point about openness in the appointment promotion system?
Oh, there are numerous. I mean, even if we just limit ourselves to the Commonwealth, I mean, a number of judicial appointment processes are open. We do have an element of openness with, for example, our parliamentary vetting, but it has become very pro forma, so it's really not very effective. At the nomination stage, where the Judicial Council is involved and where it proposes names, how do we do it? We don't even know it. It's a closed docket. It's a black box. Nobody knows what goes on there, right? Why not open it up a little bit so that we can get input, especially for those who are already on the bench. If people know them from cases they've done with them, we can involve the academy. I mean, people to review some of their judgments. We can involve many more players. But let me talk about the first question you posed about the investor confidence. In fact, it is important. Now, in today's world, where there's been a lot of convergence between countries in terms of the way we organize our economies, almost all our economies are now market-oriented, liberal economies. Our trade and investment laws and policies globally are getting towards convergence. The real competition between countries, I must say, for investment is oftentimes competition in things like the quality of the judicial system, its integrity, its cost, its efficiency. Foreign investors, of course, are not all virtuous. Some may be attracted to doing business in our jurisdiction just because they believe our laws are lax or they believe that probably our judicial system is corruptible. I'm not talking about those kinds of foreign investors. There are others who would not be attracted to us for those reasons. Corruption, when it is alleged to be part of the judicial system, increases the cost and uncertainty of doing business in Ghana.
Right.
Investors who take the risk of doing business under those circumstances should be expected reasonably to expect a premium for their investment.
Right.
So they will take more out of the country and leave less for us.
Right. Prof, Mike.
For you lawyers too, just a quick point for you lawyers too, I think it's important that we also note what this does to the legal business itself in Ghana. Okay.
Now, hello, do I have Prof on the line still?
Yes, I'm still here.
Okay. My very final question, and be very brief with that for me. What do you make of the call for audits of the judgments delivered by these judges who have been implicated?
That's a very tricky question. But I think we should do first things first. First, let us establish the guilt or otherwise of the named suspects.
Okay.
Right? Once we know that, there are, of course, certain collateral consequences, one of which is what you have mentioned, which is what to do with cases that these judges have handled. Of course, those specific cases, which the evidence on the video would show were procured corruptly, are easier to deal with.
All right.
Certainly, corruption in the procurement of a judgment should be presumed to vitiate or void the judgment. So those cases should be set aside and reopened. But there are other cases that people are talking about, which is, what about all the cases that a particular trial judge handled? Well, that's a tricky one because those are closed cases mostly. Those are not necessarily cases where corruption has been alleged to have affected the outcome.
All right.
And yet, there's a cloud now on all of those cases. These things should be handled very, very cautiously. Of course, there are superior courts have appellate jurisdiction, they have supervisory jurisdiction over some of these cases. But in some cases, the window for appeal has closed.
That's right.
They need to be handled very, very cautiously. I don't think we should rush into these things. Some precedents have happened in Kenya recently that we could learn from in terms of where cases that have been alleged have been handled by judges who have been removed for corruption and what happened to those cases. We should we should be a bit more careful on the second issue because I think a lot of other interests are involved. Those who want the cases, in those cases where there is no clear corruption alleged, what do you do with them?
Right.
You can't just say, well, you have to come back and relitigate your case.
Right.
So that requires a little bit more deliberation and a little bit more caution.
Thank you very much, Professor H. Kwesi Prempeh. Thank you very much indeed.
Thank you. Thank you.
Right. Now, back to the studio. Kweku, sure you have seen this video, perhaps seen it over and again. I am ashamed looking at some of the things I see in the video, the people that I have known and had what I have already referred to as some reverencing respect for, and see them take money in the manner they do it. I'm ashamed looking at some of them. What do you have to say?
Well, you know them personally. I don't know them personally. But there are also very, very good ones in there who refused to be lured.
Correct.
And that's the picture that the NAS project puts out there. There is no attempt to suggest that the judiciary is corrupt or all judges are corrupt. This provides the opportunity, and I know that he's written, and NAS has sent some recommendation, that's a letter to the CJ, where he talks about, if you don't mind.
Yes, go ahead.
He says, after having submitted a petition to your high office in respect of corrupt judges, I deem it a great honor to present to you some of the good and morally upright judges that I had the honor of coming across. In the course of my investigations into perceived corruption in the judiciary, I'd found judges who were ready to uphold their oaths and perform the duties of their office without fear or favor. These judges were more than ready to put me behind prison bars for even coming in to speak to them about a case. Others will not permit you to come and bribe them, and their clerks will tell you that very clearly. Anytime this happened, I left the court premises with a sense of joy and hope. They made me know that justice had no price. There is indeed hope for Ghana. Generally, most of the new circuit and district court judges were determined to do their work without any compromise. It was their determination and courage to do the right thing that motivated me every day.
The new ones?
Yes. We as a people must not fail them. We must do all we can to keep them on the right path. I firmly believe that we can do this by weeding out the bad ones and ensuring that the good ones are rather not allowed to feel like the old ones out. I present here under a list of these judges. Can I read them?
Oh, go ahead.
Justice.
Go ahead. Please go ahead. I have said that we need to celebrate these people, including even the state attorney I was talking about yesterday.
But in this protest, maybe you may give him the chance to.
So. No, please.
But well, I'm
please.
not in charge.
Justice,
I'll come to you.
Justice Kwesi Boakye, High Court, Wa. Justice Bright Mason, High Court, Accra. Justice Constance Ometou, I'm not sure I've pronounced it properly.
Yes.
High Court, Accra. Justice Georgina Mason, Dache, High Court, Accra. Justice Afia Sewa Asari Bochwi, High Court, Accra. Justice Anthony Opon, High Court, Accra. This name rings a bell. Was it the Yana case, Martin Batno-Bruce target? Felicia Gandeji, District Court, Abeka. Charles Kwesi Achampon, District Court, Dodua. Samuel Jani Korti, District Court, Ejuso. As at the time of the investigation, that was where he was located. Abdul Baki Abdullahi, District Court, Tubodo. Then Bright Ajosagi, District Court, Kodie. This tells you that the project is not out to suggest for a moment that the entirety of the judiciary is corrupt. I just assess the list. That shows that the number of judges that we have, in terms of the Supreme Court up to the High Court, is about 400. The entirety of the staff is about 5,236. If you go to the High Court, it's 106. Circuit Court is 64. Magistrate Professional 59. Career Magistrates 131. Then if you add the Supreme Court and Court of Appeals, all 400. So nobody is suggesting for a moment that there's evidence to the effect that the judiciary is corrupt or all judges are corrupt. That's not what ANAS set out to do. And that's why, and indeed, since the names of those that have been captured on the video as having been compromised have been mentioned, it only makes, I think, fair, it's a matter of fairness that those who did not allow themselves to be lured must also be mentioned. I think it's fair.
You could just hold it there for me for now, and I come to John Ndebugri. Well, you are in a very special position because you are in court for 14 of the lower court judges. Their complaint primarily, for now, is not a denial of anything, but to be giving reasonable time, opportunity, and facilities to make their case. Is that the case?
That is not the case.
Okay.
It cannot be so. You see, we are dealing with law here. And before I answer your question directly, I don't want to use the word, but I'm disturbed. And if I'm pushed, I will say I'm disappointed about comments that I've already heard so far here. Because you, the host, you've already passed judgment. You said you were shocked. You were this. You claim that you've seen the tape.
Yes, I have.
I have seen some too. I don't agree with you. I don't know whether she has seen Miss Berry, right? Or Mrs. I don't know.
Mrs. Kasati.
Mr. Tudazi, my old friend, has not seen the tapes.
He has read transcripts.
And yet he was quite ready to say that.
He has read transcripts.
A lawyer should not depend on transcripts. Please, a million suspicions do not constitute proof.
That is
authority on that. There is authority on that.
Yes, Kasina in 1962.
Ali Kasina?
Yes.
Yes. So, you haven't seen the clip, and you are saying you were shocked.
No, but you see, the authority you are referring to, Ali Kasina, says, a multitude of suspicions cannot constitute proof.
Yes.
he's not talking of suspicion. He's talking of having read transcripts. I am talking of having
if
seen
you read transcripts
videos
of a video clip and you haven't seen the video clip, it is suspicion, Mr. Host.
Okay.
I'm putting it to you.
Well, I
Very forcefully. Very forcefully.
Yeah. Just hold on for
I'm putting it to you very forcefully. That when you have read newspaper clips, especially our present day newspaper clips in Ghana, and you jump to conclusion, I am putting it to you that it is suspicion. Now, I have seen some of the clips.
Okay.
Because I was dealing with that until about 8 p.m. last night.
Right.
I am not shocked. As opposed to you. You are shocked. I don't know the ones you saw. I haven't seen all. I saw the ones relating to my clients. Some clearly, absolutely rubbish, with the greatest respect. And you say you were shocked. But let me leave that one aside. You are saying that we are just coming to ask for time. It is not so. We are saying that procedural law is as important as substantive law. The law says, you heard Professor Prempe.
Yes.
Yes. Why did he run away from this camera thing, having regard to Superior Court? It is in the Constitution, Article 146, Clause 8. These proceedings must be done, and it is in italics. In camera is in italics.
He explained that he is talking about the lower court judges.
I am coming to that.
Right.
I am coming to that. There are authorities, plenty of authorities, that where proceedings are relating to the Supreme Court, they must, pari passu, operate on the lower courts. What is the policy behind that provision in the Constitution? The policy is that when the judiciary is such a special institution, that when you have accused a member of that institution, we must investigate the allegation so carefully that when the person is absolved, the whole institution doesn't come into disrepute, or that person's repute cannot be restored. And so if it is applying to a Supreme Court judge, why will you not apply to a magistrate? The majority of the judges Kweku has mentioned are in the lower courts. They are not in the Superior Court. The majority of the 400 he has mentioned are in the lower courts. So their integrity is even more important than the integrity of the members of the Superior Courts. So we are saying that
Prof is saying though that we are not in ordinary
Sami,
times.
I beg you.
No, you are reacting to him, so I'm bringing that to
I am not going to allow you
we are
to
not
do
in
that.
ordinary times.
If you don't want to entertain me, I'll just leave, because I've been watching you from my home, and I think you don't allow people to state their case. I am stating my case. You allow me to state my case, and then you can ask me questions. When I'm in the middle and you cut me,
you are moving on now to
I am not moving. Point. You ask me a question.
You are moving from your reaction to Professor Prempe to why you are in
have
court.
Not moved. I just used Professor Prempe's intervention to explain a point I was making.
Please proceed.
Yes. And I'm saying that my clients are saying that the procedure must be followed. And that what is happening does not constitute the procedure sanctioned by the law. So you should ask me what the law says, and I will tell you. So that is what we are complaining about. The procedure is wrong.
Right.
Well, if I may just... No. Yeah, I think in fairness, that's what I'm calling it's just in the over the last 40 years that I've known. You haven't changed much. Where were the...
my height should have
back in the nukes, this kind of banter was going on. But the point I would make was that I don't think that we can go on without putting some first caveats to ourselves. one, that this matter is being handled by a competent body. We must understand that. So we are not come to sit here to adjudicate on the matter or to look at the matter. No.
Which one?
Look, I'm saying that this whole investigation that is going on, listen. This matter is under the control of the Chief Justice. He's appointed a committee. They are looking at the matter. That is not what we are doing here. We are here trying to educate the public as to what we are talking about now.
Unfortunately,
hold on. Well,
we have to, so that I can leave.
No,
I am here to defend myself.
Hold on. Yes, that is the reason you are here.
That we are not here. We are saying that that committee is incompetent. And you are saying it's competent.
No, he is just a guest here. He's my guest. He doesn't ask you the questions. I'll ask you those questions. I'm holding here.
I have a lot of work. I'm not going to sit here.
I have been reading the Judicial Service Act. I've been reading the Judicial Service Regulations, and I've been going through the points that you are making, and we'll deal with those on how investigations into misconduct of judicial and executive officers ought to be pursued. So I'll deal with that.
Yes, just 1 minute. I'll just say, okay, just because of this objection. I'm saying that the question you directed at me, how I understood is basically, what do you make of this case? I said, look, for me, without even watching or seeing or whatever, it is a scandal. The scandal is not the event, the truth or otherwise. It is that an event has happened. That is a scandal. And I'm saying that to hear that 34 judges are caught up in this, whether it's true or false, it's not the issue here. It is there are cases involving 34 judges. It's a very serious matter.
Yes, it is.
How do I see it? I say it's disturbing. You cannot stop me. Okay. That has nothing to do with
so
the
merits
of the matter.
I take note of your caveat. I take note of your caveat. Yes. I take note of the caveat that yes, I do. I do. But to the extent that this is a huge matter of public interest, we are dealing with it right here on Newsfile. Let me hear that quick reaction you wanted to give. Then we'll go back to Ndebugri to get his why they are in court.
Okay. My quick reaction is that, of course, I can understand where Mr. Ndebugri is coming from, because he's basically advocating the case of his clients.
That is so.
However, with me sitting here, I'm not advocating the case of either party, but we are not also talking about suspicions. You cannot talk about a video recording as a suspicion. I don't know what is more factual, what is more evident, what is more evidence than a recording.
His point is that you haven't seen it.
He doesn't know that. He doesn't know whether or not I have seen it, and I am not obliged to say whether or not I have seen it. A transcript too is not suspicion. It's a document.
Right.
If you are doubting the document, that is another thing, but it is not suspicion. So we are not here to talk about suspicions. No, we are talking about facts and our comments on the facts.
Thank you. Now, Mr. Ndebugri, now tell us, why are the 14 of your clients in court?
I believe you have seen a copy of their writ.
That is so.
Yes. We are saying, we had to do things in a bit of a hurry. We haven't completed. That is why I'm so anxious even to annoy you, so that you can dismiss me and I can go and continue my work.
I will not get annoyed and I will not dismiss you.
And I can see that you are resisting this annoyance. You see, there are two reliefs.
Right.
Basically, the first one is that the proceedings are instituted by the Judicial Council against the plaintiffs. They are contrary to law and or due process. And secondly, that the panel constituted by the Chief Justice is not sanctioned by law. It has no legal basis. Therefore, it's null and void, and it ought not to proceed with its work.
Okay.
Maybe we should have added a third relief seeking for or injunction, but that is not prejudicial to the case.
Okay, so explain to Ghanaians why you are seeking these reliefs, because look at how some Ghanaians are reacting to those who have already proceeded to court. And I'm reading from comments that have already been made. Yes, some Ghanaians. one says that justices seeking justice, using technicalities to escape punishment, you will definitely get your due punishment, even if it is not on earth. One way or the other, you will get it. Another one says, dear God, some people who took bribes and refused to give justice are seeking justice. I suppose they want a fair trial, but they did not give that to others. God, do you think it is even fair for them to even appeal to the law which they so despicably threw into the garbage because of money? So God, why don't you give them a judge who will collect bribe and throw their case out? A bunch of despicable beings who take bribes to pervert justice are running to justice and expect to get a fair hearing. When they denied it to others, may justice elude them like the urination eluded the hen. Then this one says, some of the judges indicted in the Anas video are now in court challenging their suspension by the Judicial Council. It's so funny. It's funny they have gone to court. Who should we pay to get their case thrown out? Will these judges take 5 tubers of yam? But seriously, these are lawyers. They may have, and I will not use the next word, they may have taken bribes, but I'm sure they will have the legalese down. The Judicial Council and the AG's department shouldn't bungle this. And the final one is by a lawyer. Out of these, about 2 of them are lawyers. One says, my criminal law lecturer used to joke about the fact that you need a criminal mind to be a lawyer. Let's believe that both they and their lawyers have their defenses locked down tight. This is the mind of some Ghanaians about people like your clients seeking that procedural justice is as important as substantive justice. How do you speak to them?
You see, this morning, before I came here, a radio station called me and raised similar questions. And when it seemed that I had convinced the interviewer of our position, he said that you may be right legally, but you will rewrite in the law court, but it seems you are not right in the court of public opinion. And my simple answer was a question to him that, well, I'm not, you journalists say we shouldn't ask you questions. But I am operating from the standpoint of the law. And the Constitution and statute have established a hierarchy of courts in this country. District Court, Court of Circuit Court, High Court, Court of Appeal, Supreme Court. He may wish to indicate to me which part of the Constitution or statute, which act or regulation has established a court called Court of Public Opinion. That is the answer to all these messages. I am not about, before I became a lawyer, you know, I used to carry guns. And if you committed a crime, I was prepared to deal with you summarily because of a sense. That is where I take a very serious exception as a lawyer to that message that you need to be criminally minded to be a lawyer.
He says he was his law lecturer who used to joke.
Well, that law, I take serious exception to that, and he should stop repeating it in public because some of us don't have that mind.
Right.
I am saying, before I became a lawyer, I was given, and Atudazi is here. Kweku is there. The young lady hasn't known me. I've been seeing her on Facebook. I didn't know she was this beautiful. You know. Now, I was given to deal with offenders summarily. Summarily. If you are driving and you cross me and I have a weapon in my car, I will come out and slap you and push you into the gutter and let you know there and then that you were committing a crime. Later on, having gone through age and being cured in age, not cured of an illness, with the greatest respect. After becoming a lawyer, and I've been practicing law close to 30 years now, I have come to the realization that we must all submit to the law. So speaking from the standpoint of the law, all these messages you have read do not make any sense to me.
Okay. So
listen.
What is wrong with the panel, and what is wrong with the process?
Thank you. That's what I wanted us to go to, instead of skirting around. You see, the Constitution is the one that gives a mandate to the Judicial Council to deal with the President and the Judicial Council. Because we are dealing with the lower courts. I'm not concerned about the superior courts unless I need to refer to some article that is pari passu.
Right.
The Judicial Council has been mandated through the Chief Justice to deal with misconduct of members of the judicial or what we call judicial office holders.
All right.
Magistrates, circuit court judges, magistrates, and even executive officers and so on. But there is a procedure for going about it.
That is so.
And in order that I am not just talking as I wish, let me go and then let us look at the authority for what I am saying. And the authority will be Article 152, I believe.
151.
151, sorry, 151 of the Constitution. You have your 151 there. I'm going to take it from you.
Yeah. Your law book or Constitution.
Mine is a compendium.
I have 151.
Go ahead.
151 says that
No.
a person holding a judicial office may be removed from office by the Chief Justice on grounds only of stated misbehavior, incompetence, or inability to perform its functions arising from infirmity of body or mind, and upon a resolution supported by the votes of not less than two-thirds of all the members of the Judicial Council.
It is, you see, I'm trying to be systematic.
Right.
I'm saying that the Constitution has mandated the Judicial Council through the Chief Justice to deal with these lower courts.
Right.
But the authority is further explained in Article 154 Clause 2. It says that the Judicial Council may establish such committees as it considers necessary, to which it shall refer matters relating to the judiciary. But even there is another provision where the exercise of that authority will be done through regulations that have been. No, I believe that comes from the Act. Now, this is what the Judicial Council seems to be relying on. Article 154, Clause 2, that they are entitled to establish committees to which matters relating to the judiciary may be referred. And our position is that that is not the case. There is an act that operationalizes this mandate that is conferred by Article 151. And that act is the Judicial Service Act. An old act which they have not been minded to amend or repeal or whatever. It is a 1960 Act, and it is CA10. That's the short title of the Act. Now, CA10 sets out the procedure.
Section 16.
Section 19, rather.
Right.
Yes, Section 19 of CA10.
Proceedings for misconduct.
That is right.
It says disciplinary proceedings in the case of misconduct shall be either summary or formal.
Yes.
And then you proceed to subsection 2, no major penalty shall be imposed on a pensionable officer in summary proceedings not arising out of a conviction.
Yes.
And that's the point you are making.
Yes. So, and when you go to the regulations,
right,
there's a provision in CA 10 which says that regulations will be made under which this mandate will be further clarified.
Right.
And the regulations say that you should inform the suspect, the person against whom allegations are made, whether the proceedings about to commence against him or her will be a formal or summary, because they have different sanctions. They have different sanctions. And you read a very important one there. So that I'm not just talking off the cuff. Section 19, section 20, subsection 1 is the one I'm referring to.
Okay.
That regulations shall be made providing for the conduct of disciplinary proceedings in cases of misconduct or unsatisfactory service. Now, if you go back to 19, subsection 2, it says that no major penalty shall be imposed on a pensionable officer in summary proceedings not arising out of a conviction. What's the meaning of that? Before you start summary proceedings against me, which will lead to a major penalty against me, you should secure a conviction in a court of competent jurisdiction against me before you can start proceedings. This has not been done. They are proceeding with summary proceedings against them, which may lead to the dismissal of the people without getting a conviction against each of them. So it is a question of jurisdiction. When a panel set up by the Chief Justice is a quasi-judicial body, it derives its authority from law. You don't act according to the law, you will not be allowed. And if you build a skyscraper out of it, it will crumble to the ground because you have no jurisdiction. Jurisdiction is fundamental. That is our point.
By the law.
Please,
by the law.
Let me hurry.
There are three levels of
Please,
major
let me hurry and
major
before
penalties.
I forget something.
Three levels of major penalties.
You don't want to forget. I too don't want to forget.
You are saying they are proceeding on a summary process, which may result in a sanction that is a major penalty.
Which is even likely.
Likely.
Yes.
But there are also minor.
Because
there are minor penalties, and you cannot
the
say.
Thing should be purged. The judiciary should be purged of all these bad knots.
Okay.
What is the meaning of that? So please let me finish. Let me finish.
Well, you don't want to deal with public opinion, so ignore those who are saying that.
Let me say.
Yes.
That. Let me comment. Anas, or no, I don't know about Anas. The information we have is somebody called
Tiger
Eye PI. Yes, I don't know about Anas.
Anas is the chief executive officer.
I don't know about
the lead
that.
investigator.
The information.
No, I'm just giving you info. Don't worry.
No, I don't want to take that information now. What I'm saying is that, please, it's very important to make this point. We commend Tiger Eye PI, whoever is that entity, for initiating the process, because that is the way to go. If you suspect that a particular person or institution or member of an institution is corrupt, or even an individual, you should go and report to the appropriate authority. That is what Tiger Eye have done. They've petitioned the president and they've petitioned the Chief Justice. It is not helpful for people to go on platform and say there is corruption without going to report. If I know that my former chief of staff, Atudazi, is corrupt, I will go and inform the nearest police station about him. He will be apprehended and dealt with. So we commend Tiger Eye for that. But the problem we have is to rush and indict the people. Indict the
Why
people.
do you say rush? What's the rush in it?
No, because when I have gone to make a complaint against Sami at the police station, the police station will not go and publish your past history. Go and publish how you were being massaged. These are matters of evidence which are subject to cross-examination, as you know. Now, you have described the people as despicable, they are rotten, they are this, you are that. Look, yes, let me conclude.
Okay,
I want to demonstrate the unfairness in the matter.
Okay,
For example, I have this one here. I just printed it early this morning. They're from Ghana Web. A person was wrongly identified and indicted. Ashite Frank Ado Ashite. Yes. And the Judicial Secretary claims that it is not true. And yet admits that, yes, he was not the one. So the one who did the investigation went and put Sami's name when he intended in the Bugre. And Sami has been vilified. So Sami has not been discharged. What is this?
Okay. Now, let's do this. Let's do this. Let's do this. Let's do this. Sorry. Let's do this. I'm going for a quick break, and I'm hoping that we can tone down a bit on the. Well, it doesn't appear we can really on the legalese, but it is important.
If you want us to set aside the law,
when I come back to you, when I come back, what I would like you to speak to will be paragraphs 4 to 6 of your statement of claim, which has issues with something about some deception of sorts in the whole process. 4 to 6. Now let me go to the phone lines before I take my break. Let me go to the phone lines and speak to Augustine Obo. He is a private legal practitioner, and I introduced him earlier as a man who has been a teaching assistant at the Ghana School of Law and a former state attorney, senior at that, who did about a decade of criminal prosecutions. Mr. Obo, good morning. Thank you for joining us on Newsfile.
Good morning, and good morning to your listeners.
Right. You say Anas lured the judges and the judicial staff. My question is, so what?
Yes, you see, the reason why I'm saying so is this. I have prosecuted a similar case when I was a prosecutor before High Court 4, before Her Ladyship Justice Iris May Brown. Similar thing, when police lured some people with cameras and tape recording to commit crime. I was a prosecutor then. Defense lawyer was, I think, Bruce Thompson. We went to full trial. They were acquitted and discharged. And the basic principle the judge used was that prosecution initiated crime and the people followed. And therefore, it is not safe for society. My point is this. I haven't read or seen any clip or haven't read anything from Anas. I only draw your attention to the basic principle. If a judge was sitting in his office, reading or writing his judgment on case A, the Republic versus Akosieji, then you knock at his door and entered into his office. And then you started talking about Francis Kuma versus the Republic. He called for the docket, and the docket is brought. You start talking to him about money, and then you proceed to give money. Then you want to become a witness that he is corrupt. From that case that I did, it's an authority. They will be acquitted. They will be acquitted. Because I am speaking as a lawyer.
As a judge.
Hello, Obo, are you on? Have I lost Augustine?
No, I'm still on the line.
Yes, you said you are speaking as a lawyer or as a judge in this matter.
No, I said I am speaking as a prosecutor for 10 years.
As a prosecutor for 10 years?
Yes.
Right.
And I have done similar cases like what Anas has done. And the result is what I'm telling you. And as a lawyer, precedent is the guiding principle. Similar thing.
Okay.
And then recently, I had another one as a private defense lawyer in a case in which the police sent some people to go and give cocaine to another policeman. And when the cocaine was given, they arrested him. We went to high court too. I was a defense lawyer. When the police finished the investigations and sent the docket to the Attorney General, the Attorney General lawyers or the state attorneys were not even willing to bring the matter to court. But due to some pressures, they brought the matter to court. I was a defense lawyer. They could never put a single witness in the box. At the end of the day, that policeman was discharged. If it had been an artist case, Anas or the public might have said that when they bring the docket to the Attorney General's department, no action is taken. It is not a matter of no action is taken. When you have seen that a crime is going on, the Constitution has given the appropriate institution the authority to handle it. You might have done your investigation. Now, let's look at it this way. You've got to see a judge. You have given him money to give a judgment. If the judgment is given, we have cases in which people took money or people went and gave money to judges. When the judge read the judgment or was reading the judgment or after reading the judgment, the judge continued to say, in the course of doing this case, ABC came and saw me and gave me this money. But I took the money because I had a reason for doing this. This is the money. Let the money be sent to this place. The money is also confiscated.
In this case, we have results. Judges took money and delivered their promise.
That is why I am
not believed to have. They delivered their promise.
That is why I am saying that based on the Republic versus Atapio Amo, the issue is clear. If
I see.
The witness was the one who initiated the crime. Mrs. Harris May Brown, who retired as a court of appeal judge, and this authority is there. If the circumstances are such that the witness was the one who initiated the crime, then it is abundantly clear. You will go to court, all right, put him in the witness and the accused boss and charge him and try him.
Just
by that authority, I'm sure this is an old principle.
I see. Just hold on briefly for me, and let's speak also to Justice Sramsai, who is a law lecturer at the Gimpa Law School. Justice, thank you very much for joining us on Newsfile.
Thank you very much, Samson.
Great. You heard what Obo has said. What he means eventually that what Anas has done, the product cannot be used for any purpose as is being sought to be used.
Oh, well, Samson, the beginning point of this discussion is the position of the law, which is that evidence which is relevant is admissible generally.
Right.
So the first question to ask is whether these tapes are able to prove the allegations. If they are, then generally they must be admissible. Now the law also provides grounds for exclusion of evidence. And those grounds are three. The relevant ground here is whether the evidence, even though relevant, would amount to, or its admission would amount to substantial danger of unfair prejudice against the accused persons. Now, the common law position, or the position of the law from the common law perspective, is that evidence which is relevant cannot be excluded on the grounds only that it was procured improperly. For example, in the case of entrapment, like the one we are talking about, the courts have always held that you cannot exclude such evidence.
Oh. Hello? Hello, Justice?
Oh.
Okay. Have we lost Justice? Hello, Justice?
No, I'm on the line.
Okay, go ahead. He said the court has always ruled that you cannot exclude such evidence because of what?
Simply because they were procured improperly. Now, in other jurisdictions where they want to change the common law position, what they do is to enact law, for example, in the UK, and to create another ground for exclusion of evidence by giving the judge the discretion to exclude evidence based on the propriety of how it was obtained. In Ghana, however, we still do not have such legislation. So, for example, in the Tagore case, 2009, one of the grounds on which the appellant challenged the decision of the High Court was that the evidence was improperly obtained because it was an entrapment. Now, Justice Apau, in that case, was clear on the position of the law. It's a court of appeal case.
Right.
That the common law position is what prevails. If the evidence is relevant, they must be admissible. Unless the evidence is not relevant or it falls under one of those three exceptions that I mentioned earlier. So I am not pretty sure of what my senior and my former lecturer is saying about a High Court decision, which, and I'm sure when I listened to him carefully, he was unable or unwilling to point out exactly the grounds on which the evidence you claim in the case were excluded. And you see, let's be clear, there are two ways that evidence could be unuseful. The first one is that it could be excluded, which means that it never went into the box. The second one is that it may go in, but the judge may give it a very light weight, which means that it won't have any effect. I think the issue here, since we are not judges, what we know from the law is that it must be admitted, or the evidence must be admissible, and then maybe the judge, after listening to the parties, cross-examination and everything, may come to a conclusion that, well, yes, this evidence, though admissible, doesn't add much weight.
Okay.
That is why we have to do cross-examination to test, the weight of the evidence. So I'm not really sure whether the case my senior is talking about is a case where the evidence was excluded or was admissible and given a light weight, on which basis the case or he lost the case as a prosecutor. Okay,
finish on this point for me quickly, and then I'll go back to Obo and wrap up also there quickly. Now, we know for a fact that some of the judges in this case are suing Anas, and they are going to make the case that he invaded their protected privacy as protected by Article 18 of the Constitution. So what you are saying means, what Obo is saying may stand and help them really rather than what you are saying.
You see, something. No one in this country has the right to commit a crime. We all have the right to privacy, and the judges also have the right to privacy. But the right to privacy is not absolute. I believe they are coming under Article 18 of the 1992 Constitution, which deals with the privacy.
Yes.
But look, all over the world, privacy is not absolute, and in our Constitution too, privacy is not absolute. Therefore, if you read carefully, Article 18, it gives exception, one of which is that for the prevention of a commission of a crime, a person's privacy will be curtailed or limited. So, and if you look at the decisions and the comparative analysis from other jurisdictions, it seems to be clear that where the information that is being gathered has a huge public concern or is in the public interest, the courts have always, subjected privacy to the public concern. Now, the issue to be addressed here is, look, we are talking about judiciary. We are talking of justice to the people.
This thing been happening for some
Did I lose justice there?
I'm on the line.
Okay, so finish up quickly on that note for me.
Yes, so I'm saying that by merely saying that you have privacy, it's not sufficient. You have to show that the privacy you are claiming does not fall under any of the exceptions, which is the prevention of a commission of a crime.
Okay.
Yes, so as it is, I think my senior Obo must come again really and be very specific on what he's actually saying, because the fact that the case is lost does not mean that it was lost on a specific ground. You have to state the ground. As lawyers, we know this, that we are not interested in who won and who lost. We are interested in the basis upon which the person won the case or lost the case. So if he's unable to provide whether it's admissibility, whether it was admissible and later placed, had a limited value.
I said that was my final point, but it also ties in another issue. As we know now, Anas has sought cover under the Whistleblowers Act. So those who are going to sue him, what do you think? How do you think they are going to be successful? Because Section 18 of the Whistleblowers Act protects him from being sued either criminally or for any civil action.
Well, that provision is about, we talk of good faith.
Yes.
So the exception to so you cannot the protection under the Whistleblower Act is actually it has its own exception. If you are doing the thing in good faith, then you are protected. If you are doing it in bad faith, and then you are not protected. So unless I know the grounds on which they are going, and if they are simply going because they think that the disclosure of what they have done is a violation of their right to privacy and all that, and I've already addressed the point that no one has the right to commit a crime. Okay. That is why there is an exception to disclosure of crime, to the right of privacy. So the point is that the Whistleblower Act will cover the person unless you are able to show that the person acted either in good faith or did something or reported the matter to an authorized authority, which in this case doesn't exist. So they should be able to tell us how they intend to circumvent or to surmount the protection given by the Whistleblower Act.
Thank you very much, Justice, for your time. And let me go back to Obo. Now, Justice refers to the Constitution. Article 18.2 says that no person shall be subjected to interference with the privacy of his home, property, correspondence, or communication, except in accordance with law and as may be necessary in a free and democratic society for public safety or the economic well-being of the country, for the protection of health or morals, for the prevention of disorder or crime, or for the protection of the rights of freedoms or freedoms of others. He's saying that on the basis of this, and added to the other argument he made, your point about the possibility of this evidence not being taken will not stand. What do you say to that?
Okay, thank you. You see, what my learned friend was saying was that the issue is not about the evidence being admitted. Surely, it will be admitted based on Section 52 of the Evidence Act. It will go in. Like my case, everything was admitted. I was sure everything was okay. But the law is that the judge can admit the evidence, but place no weight on it. In fact, it is as bad as not being admitted. The judge can admit it. In fact, in law, we call it matters not. That's how we call it in law. It matters not how the evidence was procured.
Even if it was stolen, that is the rule.
In fact, that is the principle of law. If it is called, it matters not. That's a short principle. It matters not how the evidence was procured. It is like you have murdered your wife and kept the body in your wardrobe. And then they came and forced open your gate and your door and your wardrobe, and you are complaining they have invaded your privacy. It doesn't matter. It matters not. That's the principle of law. Now, concerning Article 18, in fact, I wouldn't like to mention, some of the judges I have cited Article 18 in my cases, they disregarded it and went under it matters not.
I see.
Cited Article 18. I can mention some of the cases. But the principle they set there, this is what I've been complaining, that we must set principles for ourselves and for our future. If you disregard the principle, it becomes an authority.
Okay. So thank you very much, Augustine Obotu, for your views there. Now we'll take a break. When we return, I'll see how we can try and tone it down a bit so that all of us can look into the other details of this particular issue. And Clara would also give us some views legally about why the video may indeed be injuncted so that there will not be the public screening. We'll be right back. You're welcome back to the show. This is Newsfile, your most authoritative news analysis show. And I'd like to get Clara in quickly, and then we would get off these, high-sounding stuff about entrapment and what they call agent provocateur and whistleblower, and so he's protected and everything else. You had some concern about the manner in which the question about entrapment was being dealt with.
Yes, I do, because I said that we have to put it in the context that entrapment has a definition, and you must fall within the definition before you use it. If you look at the definition of entrapment, it talks about the persons who have been the agent provocateur. So it must be a state officer. Now it's a state agent. He is not. So he doesn't come within the terms of the definition of entrapment. And when we are talking about the issue of good faith and then the immunity and all that, I think we need to understand the context of the immunity. If you look at Section 18 of the Whistleblowers Act, it is whether or not you are entitled to immunity. You just don't claim the immunity to yourself. Somebody has to grant it. Now, before that person grants it, that person has to see whether you meet the conditions under the Whistleblowers Act to be granted the immunity. If the person granting the immunity is satisfied that you meet the conditions and they grant you the immunity, you are immune.
Okay. So as we know, he's been granted.
He's been granted, so he's immune. If anybody has a problem with that, you now have to go and then seek to set aside the immunity before you can.
Interesting. But you were talking about the fact that the entrapment issue, the agent provocateur should be a state officer.
Yes.
But there's authority that you don't necessarily have to be. And I'm looking at this case of R versus Shannon, 2001, and 1 WLR 51. It says that the alleged agent provocateur was not an agent of the state, but a journalist. It was a journalist, and it involved the supply of drugs. There was an application to exclude the evidence under Section 78 of the English Act. And this is what the judge had to say in that if the unfairness complained of is no more than the visceral reaction that it is in principle unfair as a matter of policy or wrong as a matter of law, for a person to be prosecuted for a crime which he would not have committed without the incitement or encouragement of others, then that is not itself sufficient unless the behavior of the police or someone acting on behalf of or in league with the police and or the prosecuting authority has been such as to justify a stay on grounds of abuse of process. So you would find quite some bit of authority,
under
quite
English
a number
law.
of them exactly
Under
English law.
And we know that it is only persuasive.
Yes, that give. But if they are strong enough, they should go. There
is a common law principle, entrapment. There is no statutory provision in this country about entrapment. The equivalent is Section 52 clause A, clause B of the Evidence Act.
Okay.
Which says that the court in its discretion may exclude relevant evidence if the probative value of the evidence is substantially outweighed by the risk that admission of the evidence will create substantial danger of unfair prejudice or substantial danger of confusing the issues. So there is no statutory provision for entrapment.
That was what I was coming to.
Okay.
That was what I was actually coming to.
Now, see, sorry, but I want us to move away from this quickly.
Okay.
And the other point from those who obviously are going to seek to say, let not the video should not be shown,
yes,
will be that he has taken a petition to the president,
yes,
where it involves the Superior Court judges.
Yes.
He has taken another petition to the Chief Justice, where it involves the lower court judges. In the Article 146 procedure of removing a judge for misconduct,
yes,
or stated misbehavior, the process has to be conducted in camera.
that is correct.
So, if he's presented it to them, why should he air it at the same time?
My response, I would respond that with a question, and then I would proceed. Now, is the video a petition for the removal of somebody? The video that is going to be aired, is it any process related to the removal of any justice? It is not.
It forms the core of the petition.
It forms the core of the petition. There are two different processes. Who has right to the video? Who has right to the video? Because if you are talking about an injunction, I think we should look basically at the legal issues involved. You must have a certain right that you are going to protect. My question here is, what is your right in the video? What is the right that the person is seeking to protect in the video?
In the case of J. Chung,
allow us
versus the Attorney General.
Allow her also
versus Attorney General.
Answer.
The same situation appeared.
Yes.
When they were seeking to remove the Chief Justice.
Yes.
The petitioner had put his petition, the content of his petition, out there in the public.
And the judges were at pain to explain why or not.
But
yes,
yet they still held
exactly.
that since he had brought it before them and the process was supposed to be in camera,
yes,
it ought not be advertised.
Yes, it's a judgment which I respect, but I disagree. And I would like this case to go to court for us to see, for a judge to look us in the face and then give us a reason why there should be a right to injunct it. I think it would be good for us, and because fortunately the Supreme Court is not bound by its previous decisions. But the substance, the reasoning behind that ruling, I don't agree with.
So, as far as you are concerned, the video should be shown?
As far as I'm concerned, I don't think there is any right to injunct it. Whether or not the video should be shown, I think that is a call to be made by the person whose video it is. In this case, Tiger Eye. Really? And I think the people and yes, but leaving the law aside, I think the people have to have a right to see the video. My reason is that if we look at Article 125 of our Constitution, justice emanates from the people. The judiciary administers justice on behalf of the people. I think the people have a right to information as to how their justice is being administered.
Right.
I think it is their right.
I see.
The second reason is that I think it may help us in terms of philosophical and institutional reasons. It may help us to reach that point of never again. That if we don't like what we see, we will reach that point as a people of never again. And when I'm talking about never again, it is not just to shame people, but it is an opportunity for us to look at our institutions, the checks and balances. What are the checks and balances? Are they effective? If our checks and balances are effective, at some point, the 34 cases shouldn't have happened.
Right.
The fact that it has happened means that there is something wrong with our system. And it is time to have that discussion.
Must also see it.
And we need to discuss how to fix the system.
Interesting. Well, in the coming days, I have the feeling, and I think I have my hands on this, that they will not only seek to injunct the viewing of the broadcasting it, but also actually the question of the immunity that has been granted and asked, whether or not there is any authority to grant that sort of immunity against prosecution, whether criminally or civilly. But Kweku, when you hear this things that rates are flying left, right, and they are going to seek to stop the whole Ghanaian people from seeing the video. What do you make of it?
Well, this is a democracy. So they are entitled to make that choice. After all, they are using the law courts. They are using legal remedies. So in principle, I'm not going to say that they are wrong. I disagree with them. But they are entitled to make that choice. And I think that if we're all committed to the democratic exercise, then we should not be unduly worried. Anas shows his commitment to the same legal regime by petitioning the president and the Chief Justice. And the processes are unfolding. So he shows he's a law-abiding person. He's also shown that he doesn't want his project to be driven by rumors, suspicions, speculations, and whatever, but hardcore evidence. And that's why he proceeded by capturing it on video. My brother Inde, who I've known for many, many, many years, thinks those he's seen are rubbish. He's entitled to that judgment. The determination as to whether they are indeed...
I said some of them.
Yeah, I said some. Exactly what I'm saying.
Admitted of that even I walked out of one.
Yes. I'm still speaking the same language you are speaking. But fortunately, the determination of that rubbish is not in the hands of my brother.
Okay.
It will be before a certain panel and the appropriate forum. The interventions on the radio by phone, I found some quite interesting. See, so far, since Anas began this undercover journalism, which is a branch in journalism,
right,
internationally recognized, with all his methodologies and all the rest, some of his cases have gone to court, driven by the Attorney General's department. The cocoa smugglers,
right,
they were jailed 16 years. His evidence was admissible, was admitted, and used as the material for prosecution. The Chinese sex mafia, human trafficking, they were jailed together 42 years. The Tama Harbor case, 12 people were fired by the appropriate authorities. Nana Akwesi Agyeman raping the 13 girls, 15 years, he's in prison as we speak. The Ricardo cocaine saga resulted in 8 years conviction. The Registrar General's fraudulent signature story resulted in 4 years conviction. So yes, somebody may refer to a certain precedent that resulted in a different way. I am giving account of this, all driven by the Attorney General's department. So whatever a former state attorney says, well, I hear.
Yeah, and very recently, the Dr. Ali Gabar's case, the defense tried so hard to exclude the recording Manasseh Azori, took. We went to court and made a point that they ought to go in, and he went in.
Yes.
It's on the basis of he was...
and he failed.
Yes.
So somebody can continue doing a hypothetical and speculative analysis. We are focused in terms of analysis project. It's been sent to the appropriate bodies. The appropriate bodies are dealing with it. Inde has problems with some of the procedures. Those are legal things. Yeah. He's entitled to challenge. I love such things. I have to be very honest with you, because that's what enriches the democratic culture that we are all building.
Thank you.
Yeah,
now,
okay.
Nana, you have heard Mr. Rawlings, President Rawlings say that we ought to tread with caution, even though he says that the indicted judges were motivated by greed. He, however, says, I feel genuinely sad about it. I guess it shows some are just as vulnerable as most others. Times are really hard, and there is no doubt some would have done it out of greed, like some of our politicians, businessmen, and so-called men of God, and others to profit from politics by releasing armed robbers and other criminals back onto the street. Then he says, It is important, however, that the relevant institutions and authorities take the necessary steps to investigate fully these revelations and deal appropriately with the guilty culprits. The media and members of the general public should exercise a lot of circumspection and restraint so we do not end up bringing the reputation of many members of the judiciary who have their integrity intact into disrepute. He issued a statement.
Sure.
President Rawlings issued a statement and said this.
Yeah, I'm seeing in the nodding he said that I'm happy about it. You know, basically, I think that...
You are happy because I'm nodding.
Oh, yeah. Because in approval.
I agree partially.
Yes, you agree. Yeah. You see, I think that possibly some of us are not appreciating the depth of this scandal, what it has done to the judiciary. Whether it's true or false, it's not an issue. That's not the issue. That the fact that this is a very serious indictment that's been raised, people can go and be acquitted, be cleared. But if we've reached a bridge, we need to cross the bridge. We need to look back into our judiciary. We should have a very clear mind. You know, we shouldn't be looking out for scapegoats. We shouldn't be looking for shortcuts. You understand? From the Chief Justice down, the lawyers and everybody should open his mind. Allow people to raise their criticisms. You understand? Whether by radio or whatever. And then we come up with a new, reinvigorated judiciary. Because a very high level of confidence has been lost. You see, and this is my concern. And I think that President Rawlings' concern is wrong. But at the same time, I think I also support the point that he's making, that quite clearly, these are people, first of all, these are allegations. They have not been proven yet. That is one. That's why I tell you, there are no caveats we should put in. One, these are allegations yet. Two, under our jurisprudence.
You see, as a lawyer myself, I find myself in the same situation where I say, yes, these are allegations. But you see,
until proven.
But you see, yes, everybody is innocent, Article 19. Exactly. Everybody is innocent until they are proven guilty.
Yes.
Okay? But here you have the ocular proof.
No.
But people have committed murder.
That's the very point I'm coming to. I'm saying that let us not abandon our jurisprudence at this stage. The philosophy, for our criminal law is that a man is, innocent
until proven guilty by a court of competent jurisdiction.
So we'll put them through, even if we've seen something that appears to be them.
Why do you think some of them were in a hurry to tender their resignation?
I wouldn't comment on that. I'm saying, I think that we should all.
No, for me, that tells me an admission of guilt.
Samson, these people administered justice when they were in office. The least we can give to them as a credible...
No, not when they were in office.
The video also shows that they administered...
No.
They gave judgments.
No.
They are still in office.
There was one occasion a judge was being told, we hope you will do justice, and he says no. He says no. I deliver judgments, not justice.
No, Samson.
We are talking about facts, not crimes.
No, I don't share it. You see, the beautiful thing is that we've all agreed to a constitution, and there's a constitutional process, and that process is on. That's why I said that India has issued a writ. Let the writ go through. Yeah. You see, so let's not prejudge what the committee is doing.
Okay.
After the committee has come out with its report, and it says 34, there's nobody guilty. We understand.
But if they come out, because we are asking that the committee should not operate, and you are saying that we should wait for the committee to.
No, but that is
we are saying.
Listen, this is law.
So go away from there.
No,
allow the court to decide whether they will proceed.
No, just a minute. Allow me to land. In this point is that I'm saying that if you issue a writ, you don't come and sit here and justify it.
No, I'm not justifying. But you are saying that the disciplinary committee, we have issued against
until you stop them.
Yes,
they are lawful body.
Thank you.
You haven't stopped them yet.
Okay, now here.
If I made that principle, I said that they are justices of the law. They've admitted justice to people. the least we can do, even at this time, is to give them justice. Even if they didn't do so in some cases, let us show them that there's a proper thing, and that's what we've agreed. We are a civilized society.
You agree that the video should not be shown?
Oh, no, I think the video should be shown. And the reason is very simple. You see, I've heard Mr. Samokujetu and others say that it should not be shown.
This is what Samokujetu says. Let me quote him properly. He says that Anas did the investigation with a purpose, and he spent money doing it. He does not need to ask us whether he should release it or not.
Yes.
It is not, if it is not released, will he achieve the aims of the investigations? So Anas should be able to take a decision to release it. In any case, one of the tools of fighting corruption is naming and shaming. So there should be nothing wrong with releasing it. However, he felt that, we should wait for the process, so it would be best to shelve it.
You see, I want to draw attention to 146.8. It says that all proceedings under this article shall be held in camera. You see, all the proceedings. What do you understand by the proceedings? The issue of the tape is not in issue. You understand? The issue of the tape itself is not in issue. It is not.
That's the evidence.
No.
That is the evidence.
Let me finish. The issue of the tape is not before the committee.
It is.
You understand? Now that
the tape with the transcript.
I'm saying that the issue that there are two issues which have been given to the committee. One, to identify the people in it, whether they are the judges, and two, whether they took bribe. That has nothing to do with the tape that is in the public domain, or the transcript of which is in the
committee already has identified the people. It is only inviting them to come and say why they should not suffer sanctions for misconduct.
So what's the problem with the tape? The tape is not an issue. That's the point I'm saying.
Okay.
It is not a subject matter before any tribunal or whatnot.
Interesting.
And secondly, I agree with Clara that, listen, I think unless you don't understand the extent of the damage to the judiciary by this event, we will not move. We do have to move towards saying that we should restrict or injunct the tape. Let people see it. There will be a bigger and a greater understanding of the issues at stake. And let's see whether the committee that's been put up will, will do the right thing or not. Actually, that's how we went through the Supreme Court, case. Everybody in Ghana was satisfied that whatever it is, there was a trial of some sort. Some people disagree with the final conclusion of the presidential trial, but at least we saw it. It's happening in Kenya. When we come to the crossroad, we must take a decision as a people. And I'm saying that the judiciary, this is their time. They have an opportunity of, restoring confidence back.
Okay, thank you. Thank you. Now, you obviously will not agree to showing the video.
Why do you think so? Well, I mean, you should ask me whether I agree. But obviously. Anyway, I will allow you. You see, I am surprised that Mr. Tudazi and I believe my younger sister here are saying that the video is not part of the process. What is the process? With the greatest respect, just hold your horses. What is the process? I'll refer you to Article 146, Clause 3 of the Constitution. And if I have your permission, Sammy, I'll read. If the President receives a petition for the removal of a justice of a superior court, other than the Chief Justice, or for the removal of the chairman of a regional tribunal, he shall refer the petition to the Chief Justice, who shall determine whether there is a prima facie case. Prima facie in italics. How is the Chief Justice going to determine this? The Chief Justice has to review the tape and find out. I said I saw some of the tapes. If I use the word rubbish, I am using this opportunity to withdraw that word and say I don't think I used the rubbish in connection with that. I used rubbish somewhere.
No, you did. In the
no, I'm very sorry. I think that I didn't think that those allegations could be sustained against those clients of mine.
That's
what I saw.
Unsustainable.
So what I'm saying is that you cannot determine whether there's a prima facie case without viewing the tape.
Obviously.
Now, so if you are now going to publicize the tape in advance to the public,
what's wrong with it?
oh, you want the public to determine whether there is a prima facie case?
It's not the public.
The tape is part of, it is the crucial evidence supporting the allegation. So it must be dealt with in camera.
So your problem is the timing of
it is the timing. Look, personally, having seen what I have seen, I don't have a problem with the tape going. In fact, even from day one, I felt that the tape should go public.
It should go.
But looking at the law, it's going to create a problem for us.
Right.
But I just want to wind up because I may have to ask for permission to rush because I'm doing some further work.
You can't go.
Yes. I wanted you to
there's
something.
There's a religious leader who says that we should pardon them. After all, God forgives all of us, so we should just forgive them.
That's baloney.
I told you that I'm talking constitution and statute. I don't see any religion in the statute, any statute or the constitution. He is part of the court of public opinion. So he's entitled to his opinion.
Okay.
I mean, of course, if the people are convicted or sacked or tried and convicted and even sentenced to death, the Almighty can still forgive them.
Okay.
So that is
right. Let me read some of the text messages that have come through to you. This one says, interesting, and my apologies to my other panelists who are waiting to join me to do the last segment, and we'll see how we deal with that with a bit of speed. But before you go, there are those who are saying that beyond this, a disciplinary process, there ought to be prosecutions. Police have started issuing statements all about the place that they are monitoring. People are asking them, what are you monitoring really? That there ought to be prosecutions after that, because they are crimes.
Yes, if crimes have been committed, or if the prosecution or the Attorney General's department believes that crimes have been committed, of course, nothing stops them from initiating the prosecution process. They have the discretion at any point in time to decide whether or not a crime has been committed and to decide whether or not to prosecute.
What further punishment do we envisage giving to such persons if you have lost your job, you have gone through such shame? What again? What punishment again?
Well, but the laws, crimes are committed against the state. So I don't think it is up to us to determine. But if the relevant state institution believes that a crime has been committed, it is within their mandate to do what they think is right.
Koko, what do you say to those who are quickly saying this is a failure of the system employing people into the judiciary? The law says that the threshold of entrance is a person of high moral character and proving integrity. After that, they take an oath to do justice boldly and fearlessly and without ill will or affection. These people did not uphold this. It means that the process that got them there was wrong in the first place. They are not persons of high moral integrity and so on.
No, if you make an absolute out of that, you'll be inviting us into the realm of fallacy and absurdity. Why there were others who refused. And we have many more, as we said, that nobody knows really. So you can't prejudge them. Okay, we have to be very careful.
Right.
The system showed that some are of high moral character. That is the video.
Right.
Showed that. And for that matter, we can even multiply. There are many more out there the same way.
I believe so.
So I want to be very cautious in that.
Okay. There are those who are saying it's a failure the Chief Justice must take ultimate responsibility for. What do you say, Nana?
Well, I wouldn't personalize the issue at all.
No, they are saying best practice elsewhere.
Oh, exactly.
The head will resign.
Well, generally yes, but what I said from the beginning was that this is a matter of scandalous, proportion. I mean, really, we should be looking at a point of let's review our system, the system that we've inherited, the judiciary as of today. We need to look at it. Let's look at the best practice, mode of appointment, training. What goes into the training of a lawyer in the first instance? Most lawyers, are trained in the legal thing. They have very or little knowledge about administration and management. They get promoted or appointed to High Court. Immediately he becomes in charge of the administration of the region. Now he doesn't know a shred of thing about administration, and then the registrars and whatnot play games around him. A lot of what we are talking about is about that. The court officials and whatnot who are manipulating people who do not know. Of course, that is not an excuse for an active participation by some of the people that we are talking about.
Right.
Yeah.
Yes. What do you also say about that part of the Chief Justice? And again, I've asked the question. Lawyers, we should also look deeply into ourselves.
Absolutely.
Do a deep introspection. How many times, for example, haven't you been asked by that clerk or done things in such a way that you are compelled to give some money, some lunch, before that injunction order is typed out for you, or that bailiff who has already been paid goes to do effect service and so on.
or a missing docket and all that. That's what I'm saying. That it's a
don't let us. You see, you are generalizing the question. We are dealing with judicial officers, who are misconducting themselves. So I would prefer to deal with that and leave this. If I give 5 cedis for a clerk to go and buy wache and eat because I see that he's hungry and he's unable to work, it's no problem.
So that he will type your way?
No, not so that he will type. But,
but that's the point.
My brother, and I think he should go and eat. I mean, I give, even I have coins in my car all the time. At the crossing, I give to all these beggars.
But when you get to the typing point, you will never get that piece of paper until you have paid something.
That is beside the point. The problem is that we are dealing with a very serious problem as
okay, so quickly, we are
yes, so I'm saying that your question is actually whether the Chief Justice ought to step aside. I agree with Atu that it's not about Nana, that we should personalize the matter.
Right.
Even where I disagree with him is where he keeps on saying that it's a matter of monstrous this, that, and that. Nothing has been proved.
The scandal.
Nothing has yet been proved. When it has been proved, then you can ask the Chief Justice to resign. But if everybody is cleared, why do you ask?
Yes, what's the point?
A little check will tell you that there have been instances in the past, even in recent past, where some judges and magistrates have been cited for bribery, corruption, and dealt with. They were dismissed. This analysis thing has expanded the scope and coverage, and with more terms of hardcore evidence. So the question now arises as to, are we going to stop at just dismissal? Or are we going to go beyond dismissal? Because people will be wondering whether the earlier dismissals had any real deterrent effect.
Right.
So that's where the whole matter is going.
Clara, those who have been let go, who were freed because their justice freedom was bought for them, they have to be rearrested and retried, right?
Well, of course, any judgment that if you can prove it was procured by fraud, it is not
valid. You are looking in the video and the gentleman. They went there, they some of them, after they pay, they go into the court on the day of the judgment and they cover the judge signing off on the guy that, look.
But until that judgment is set aside, it is still a judgment of the court. So if you rearrest them and you start trying them, they can always raise the defense of res judicata. So you have to have that judgment set aside for being obtained by fraud. And then you can trigger the process again.
Interesting. There's one name. There's one name that I found quite interesting. Names have been mentioned. One, Justice Kwame Ansu Jiabo. He was High Court judge then. A case of alleged bribery by a litigant was leveled against him.
Yes.
The matter was referred to the committee to investigate and submit a report. And then he sued later on that. I'm not sure what happened in the Supreme Court on that. But you see, his name is back
New areas reside.
Yes.
New areas.
That's why they said the rules cannot apply to him now.
Some last year or two, I was handling a case involving a high court judge who was being prosecuted for stealing. A high court judge.
Yeah.
I mean, two high court judges had to handle the case. So there's nothing really new.
All right.
It's the scale.
It's a scale.
Okay, now let me try and run through some of the messages that you have brought in. This one says, Sam, in the name of fairness, how will I feel if my father, a SEPS officer, was shown as having collected bribes by a nurse, but as for some other people, theirs is to be treated specially when it's all the same crime? The judges should have been aware of the repercussions, including loss of confidence in the judiciary, but took the risk anyway. I beg, let the video be shown. This one says, it appears you had a tough guest in lawyer in Debogre, but I must commend your, okay, the commendation quickly, scroll it up. I thank you for the commendation. This one,
the same thing was a very long one.
Wow. Okay, that's a letter of commendation. I'll finish and read it. Thank you very much. This one, Kwekudria in London says, if any of the judges are found guilty, it automatically gives legal room for review of cases tried by them. Litigants who lost their cases, and especially defendants who were found guilty as charged, will have the right of appeal or review. In such cases, the statutes of limitation will not apply if it has been done here in the UK and must be done in Ghana for the sake of justice, fairness, and equity. Kofiata in Cambridge says, it is important to point out that the judges who are allegedly involved in the corruption saga in their announced tape have not been corrupt throughout in their judiciary practice. The corruption allegation is only, and he emphasizes only, case specific. As a result, let us be magnanimous in our dealing with the case, without necessarily throwing the baby with the bath water. Ibrahim in Tamale says, I'm following the legal postulations from your panelists and legal brains that you call to speak to the issue. I just want to ask these questions. One, if the judges claimed they were lured, did they collect the bribes and pronounce verdict that reflected what they agreed with the bribe giver? Two, what about the poor souls they sent to prison because they lacked the resources to buy justice or injustice? Three, Mr. Host, from the foregoing, if ordinary citizens arrest an alleged criminal, do we expect them to march the alleged criminal to the police to be processed for court, where a known bribe-taking judge will be adjudicating on the case? That's the question you are asking. But once again, we ought to deal with these things with caution. There are hundreds of noble judges with integrity who are doing their job professionally and being fair to the system. So, like everybody else has said, let's not, throw the baby together with the bathwater. Thank you very much, gentlemen.
That's right.
We'll take a quick break. We'll be right back.